Hi, thanks for joining me. This is utlradio.com, your business success and legal information station. Brand new show today. This is our brand new live legal and business Q&A, law basics and more. With me, your host, Peter Lamont. I'm glad to be back doing live shows. Let me tell you a little bit about the new format here for the live show. So every Thursday at 10 a.m. Eastern Time, we're going to be doing a live show that will be streaming live on blogtalkradio.com. You can get to that by the links that I provide on the social media sites affiliated with utlradio.com, or you can go directly to our brand new rebuilt, redesigned site, utlradio.com, and you can click on the link there and listen to the live streaming podcast. Now, what's so great about this live show is that it's going to give you the opportunity to call in and talk to me directly. I'm going to give you the call-in number now and then a few times throughout the show. It's 347-855-8831. What's going to happen when you call in? And that's this idea of a live legal Q&A show. Now, for those of you who are brand new to the show, let me just explain to you a little bit about it. So utlradio.com is really a do-it-yourself or self-help resource center for legal and business issues. I want you to have enough in the way of practical knowledge to be able to handle some of your own legal and business matters without having to hire a business consultant or a lawyer. And so that's the whole premise behind utlradio.com. You can read more about the backstory, why I created this, right on the website. And you just click on the About tab and it'll tell you everything today. So today on the live show, I want to bring in a discussion about something that I went through yesterday, which is I testified at a deposition. I was a witness for a particular company that I represent, and that's so unique because most of the time a lawyer is the one asking the questions, not the one having questions asked of him or her. And if you are regular subscribers to the YouTube channel, you'll know that, I guess, a day before yesterday, I talked to you a little bit about depositions and what it is, how it works, why you need to know about it, especially if you're going to be handling your own legal matter. And I figured today I'd give you some insight into what happened yesterday. So we're going to talk about that. Then we're going to open it up for the live questions. And I've got some questions I want to go through that were previously submitted via email this week. Everything from buying a car to being wrongfully suspended at work. Can you sue a builder? Do you have grounds for a lawsuit? Unpaid debt issues, verbal agreements, and temporary workers. A whole host of questions we're going to get to. If you're in a lawsuit, if you're representing yourself pro se, if you're handling a matter on your own, you at some point, if it's litigation, will most likely be faced with either the choice of taking a deposition, or you might be forced to give or provide deposition testimony. So I want to talk for a minute about the whole process. Some specific information. Now, you've got to know that depositions can be used for different purposes. Some of them are to make you admit something. Some of them are just fact-finding, but you have no idea going into one what this person is looking for. So after being there 3-4 hours of giving testimony, you can get tired and you can start to lose focus. And that's when some of these attorneys will sort of introduce the testimony or introduce the questions that they want you to give them a particular answer on. And you can generally tell their demeanor changes, their facial expressions change, and okay, that's a flag. I've got to be careful with what I'm going to say. I need to really thoroughly think about the question before I give an answer. If you want more information about depositions or you want to hear more about what I did yesterday, you can contact me. I'd be happy to talk to you about it. You can go to info@utlradio.com. Be very happy to discuss the details. And if you've got questions about deposition testimony in general, go ahead and contact me. You can call, email, however you want to communicate with me. Send a message on Twitter or Facebook. Be happy to answer your questions. But next, let's jump into, was I wrongfully suspended? Now, this happens all the time too. Employment issues come up. And, where do you turn? How do you know if what's happening to you at your job is legal? Every single person I've ever spoken to who is listening to somebody else talk about problems at work, what's the one thing they say? Sue them. Oh, that's discriminatory. Sue them. It is far more complicated than that, than to just say sue somebody. Let's look at this question, okay? This question says, I work for an answering service. I took a message from a caller. The number in the telefield was correct. I rewrote the number in the message field and typed one number incorrectly. So instead of it being 904, it was 906, but the correct phone number was on the template. I sent the message to the supervisor so she could update it in the system. The supervisor did not verify the number and put in the incorrect number. A message with caller's information was sent to the wrong number. And the asker of the question was suspended due to a HIPAA violation. She was told that it was her responsibility to verify the number before she entered the information in a database. And her question is this her supervisor's fault? And was she wrongfully suspended? Apparently she got suspended for this mistake. Now, a lot of factors here. First of all, most people in the U.S. are considered to be at-will employees, and that means that you're not working pursuant to a contract. If you're a teacher or another profession where maybe it's more typical to have a contract, that's a different story. But most of us here in the workforce are at-will employees. That means that you can be fired for any reason, as long as it's not a discriminatory reason. And you can, if you're the employer, if you're the worker, you can quit whenever you want, okay? That's what at-will means. It means you can be fired anytime as long as it's for a non-discriminatory reason. It could be anything from your employer can't afford you, your employer has changed direction and doesn't want to, retain you to do whatever job you were doing. Just keep that in mind. Now, what's interesting here in this question is this idea of a HIPAA violation. Anyone know what a HIPAA violation is? Well, basically it is a privacy law that affects the medical industry, and it prohibits medical providers from doing certain things, and it typically involves disclosing private information. But HIPAA is a weird thing because let me ask you this. You ever go to a doctor's office and go up to the front desk and sign that sign-in sheet? And on the sign-in sheet, you can see the names of all of the other patients that were there before you. Well, theoretically, that's a HIPAA violation because the privacy rights of the individuals on that sign-in list are affected. Another HIPAA violation, just to give you an example, would be if a receptionist or secretary or doctor or nurse working at a medical facility accidentally faxed or emailed private patient information, it's otherwise known as protected health information, to the wrong person. Completely accidental, let's say. Let's say that the nurse accidentally sent a patient's information to the wrong person simply because they interposed the number. That is technically a HIPAA violation. So this person wrote down the wrong number, gave it to the supervisor, and when the supervisor sent out the information, then she realized, hey, wait a minute, this is the wrong person, and I disclosed this information to the wrong party. So that is, in theory, a HIPAA violation. And so the supervisor suspended the employee. Do you have a claim here? No. Let me explain why. First of all, at-will employee, right? You were suspended not for a discriminatory reason, but because you did something improper. You did commit a HIPAA violation by not double-checking the number. Now, is it something you did intentionally? Did you do it with malice? Did you want to hurt somebody? No. It was a mistake. We get that. But can you be suspended for it? Yes. And I think that, where you want to go to look for that information is in your company's handbook or policy manual to see what exactly, the ramifications of a breach in your duty is. I think in that instance that the employer is not at fault for suspending you simply because it was you who wrote down the number incorrectly. And again, not intentionally, but accidentally. But in the world of HIPAA, it really doesn't matter. So, I understand where you're coming from, but I don't think you've got much going for you there. All right, moving along, let's go to the next question. Do I have grounds for a lawsuit? An item of mine was sold with written agreement via text. I would receive payment, which I never received. Do I have legal grounds for a lawsuit? Again, a very general question, not a ton of information here for me to go on. But in theory, you would have a breach of contract claim, okay? It really depends on more of a factual analysis here. Was there, you say here that there was a written agreement via text, which that could constitute a contract, so long as the elements of a contract are created here. So the fact that it's a text message, that doesn't do anything to me. It doesn't make me say, hey, wait a minute, you don't have a contract. But what I'd want to see is, what are the terms and conditions? Were all of the elements of the contract fulfilled? Was there an offer, an acceptance? Was there a promise to pay? You know, it seems to say from your question that there was. So simply stated, it looks like you provided them with your item and they never paid you. That constitutes, generally speaking, a breach of contract claim. Now, we talk about on this show all the time the fact that why would you want to represent yourself? And one of the reasons is you can't afford a lawyer. The other reason is that it doesn't make financial sense for you to hire a lawyer, even if you can in fact afford one. So what you've got to do here is figure out the value of your contract, the value of what you sold. Let's say you sold a $100 item, and that this does constitute breach of contract, okay? Again, hypothetically. Well, you would have a claim. But do you want to go hire a lawyer? Do you want to spend $400 an hour, $300 an hour, whatever it might be? Because that's a situation where we talk about on the show often, it doesn't make financial sense. Why hire a lawyer? This is something you should be able to do yourself, because you're going to be paying more than you could ever hope to recover. Does that make sense? Now, keep in mind that there are other factors here that have to weigh in. Where was the person that you sold this to living? You talk about via text. This could be an online auction. This could be, one of these sites, like Wallapop is one of these sites where you can post things and you can sell to people. It's not like eBay where there's more of ground rules, and there's not the PayPal protection that you might have. So you got to figure out, where is this person? Is this person in your state? Because you might have jurisdictional issues. It might cost you more money to go after this person out of state than it would to just say, wow, this was really dumb on my part. I should have gotten paid first and then sent out the merchandise. But these are factors. They're realistic factors you've got to consider before you just jump into this and end up spending a lot of time and money. So I hope that answers your question. But again,